Right. You are now live.
Hello, everyone. Thank you for joining us. You are viewing the webinar today for the Attorney General's Access to Justice COVID-19 Task Force. The subcommittee that is presenting today is the Surviving Abuse, Neglect, and Exploitation Committee, of which I am a co-chair along with Shelley Mintz. My name is Delegate Sandy Bartlett. I serve in the Maryland House of Delegates, and I serve on the Judiciary Committee. My co-chair, Shelley Mintz, is with the Office of the Attorney General, DJS. I have some excellent presenters today. We are going to be talking about protective orders. Ashley Young is the managing attorney at the Sexual Assault Legal Institute. She will be one of our presenters today. The Sexual Assault Legal Institute, also known as SALI, is a program of the Maryland Coalition Against Sexual Assault, also referred to as MCASA. SALI provides direct legal services for survivors of sexual assault across the state of Maryland. MCASA is the federally recognized state sexual assault coalition whose members include Maryland's 17 rape crisis and recovery centers. We will also have Bobby Stayer. Bobby is the Director of Advocacy for Family Law at Maryland Legal Aid. In this role, she supervises the Victims Assistance Project, a project that partners with community agencies to provide legal representation to survivors of domestic violence, sexual assault, and human trafficking. She has worked in a number of nonprofit settings, both as a counselor and as a lawyer, including 30+ years with various domestic violence programs. During that time, she was an advocate at 4 domestic violence programs and was both a staff attorney and a managing attorney at the House of Ruth Domestic Violence Legal Clinic. Dorothy Lennick. Dorothy has been an attorney at the House of Ruth Domestic Violence Legal Clinic since 1988 and has been the director of the clinic since 1994. She supervises and directs the clinic's domestic violence litigation and advocacy efforts. Ms. Lennick is also the registered lobbyist for the House of Ruth, Maryland. In addition, Ms. Lennick is the vice chair of the Governor's Family Violence Council, is a past chair of the Maryland State Bar Association's Family and Juvenile Law Section Council, was the chair of the Baltimore City Domestic Violence Fatality Review Team, and she was the co-chair of the Bar Association of Baltimore City's Family Law Committee and its task force on the effect of domestic violence on children. As you can see, we have extremely well-qualified presenters today. We're going to start with Bobby Stayer. Bobby, next slide, please.
Thank you, Delegate Bartlett. And I want to say thank you to the Attorney General for finding these issues to be important enough to allow us to investigate and to educate other people about the effects of abuse and neglect on Maryland residents, Maryland citizens. We're going to October is Domestic Violence Awareness Month, so this is a really good time. It's a timely subject to have this webinar. Tonight we're going to talk about peace and protective orders. And peace and protective orders are civil orders issued by a judge that order one person to refrain from committing certain acts against others. Tonight, we're going to specifically talk about protective orders, but you can get further information about peace orders from many of the resources listed at the end of this webinar. Next slide, please. Before you decide to get a protective order, there are some things that you should consider. It is likely that you know the other party better than any others. Do you believe that you'll be safer after you get the protective order? I've had a number of clients who have come to me, and we've really had long discussions about the fact that they didn't believe that involving the court or involving law enforcement would make them safer. So I think that's something you really have to consider before you decide what you're going to do. Another thing that you need to consider is if you have any issues with immigration or status, any questions about that, you should talk to one of the legal service providers, and you should talk to perhaps an immigration attorney. You certainly are not barred and don't need any status to get a protective order, but there are other concerns that you may have, and you may want to speak to another legal services provider. The next thing that you need to consider is the abuse you have experienced the type that qualifies for a protective order? And I believe we are going to put in the chat a link to the protective order petition. You can look at those under the domestic or district court forms, and you can take a look at that before you go and file, so you know the kinds of abuse that needs to have occurred. And I say that because sometimes people will go in, they don't check the right boxes, or they don't have an abuse. They haven't experienced abuse that falls under the act. And then when they leave and the order's denied, the other side feels like the court has approved of everything they're doing. So, and it just sometimes makes matters worse. So make sure that the abuse you've experienced qualifies you. Figure out what the best time is you want to go to the court to find the order. You know, if you have kids, where will they be? Where will they stay? Sometimes the order is not served right after you get it. And so should you plan to be out of your home till your order is served? You know, there are just considerations that you should have. And certainly Maryland Legal Aid has a hotline. House of Ruth has a hotline. You know, there are any number. Sally has a hotline. Any number of agencies that have someone you can talk this over with. When you go to get the protective order, have a description of the abusive party. Include any tattoos or distinguishing marks, and you can give that to the court because it will make it easier for the sheriff or for law enforcement to serve the other party. Be aware of other addresses where the other party may be served if they're not at your home or at the home that they generally are in. And that includes work addresses, you know, family addresses to include. Next slide, please. After you have gotten the protective order, keep a copy of your order with you at all times. Give a copy of your protective order to the local police, to your employer, to the security personnel at your workplace, sometimes to your pastor, you know, wherever the other party knows that you spend time and may come there to approach you, you may want to give a copy to those people. Give a copy to everybody who cares for your children, daycare, school, babysitter, church, and make sure these people know who has permission to pick up your children and who no longer does. Make sure your friends and family and neighbors know that the other party no longer lives with you, and they are to call the police if they see this party around your home. If you're awarded use and possession of your home or apartment, is it possible for you to change your locks? Is it possible to install additional security systems, additional locks, bars on the window, electronic sensors, you know, one of those, I'm not very technologically savvy, but one of those Ring doorbell things, you know, however that works. So look into additional security systems. And as you go about your daily life, you might want to vary your routine. Now, this may not be as pertinent during the pandemic, but you want to vary the way you go to work, or using different banks, different routes to school or to church, just so you're not so typically easy to find. Next slide, please. Oh, and I'm sorry, we don't need to go back, but we will also put in the chat box a link to where you can find a more extensive template of things that you might consider when you're doing safety planning, when you're determining when to get the order and how to get it, okay? Who can apply for a protective order? This is in Family Law Article 4-501, and it tells us who is eligible for relief. The current or former spouse of the party, a cohabitant of the other party, a person who has had a sexual relationship with the respondent within 1 year of the filing of the petition, a person with a child in common with the respondent, person who is related to the respondent by blood, marriage, or adoption, and a vulnerable adult. We're going to talk a little bit more about that in a slide or two. There's a new law that took effect on October 1st, 2020, and it's the survivor of a survivor of rape or sexual offense within the past 6 months is eligible for a protective order. Now, if you look at these people who are eligible for relief and you believe that you've experienced domestic violence, but you don't see yourself as one of these categories, you should look into a peace order. And you can get information about that, again, from any of us who are resources at the end of the webinar. Next slide, please. What is a cohabitant? A cohabitant is someone who has lived with the respondent for at least 90 days within the past year and has had a sexual relationship with the respondent. Next slide, please. And a vulnerable adult protective order is a sort of separate category of protective orders. And one of the people that's eligible for relief is a vulnerable adult. A vulnerable adult is defined as an adult who lacks the physical or mental capacity to provide for their own daily needs. A vulnerable adult protective order may be brought by the state's attorney, by the Department of Social Services, by a relative or another adult living in the home. So it does not have to be brought by the person who's experiencing abuse. And that person, frankly, doesn't even need to be at the hearing. The respondent in a vulnerable adult protective order also doesn't have to be a relative or in a relationship with the petitioner, but also could be a caregiver of the vulnerable adult. And that caregiver could be someone who comes to their home or someone who's taking care of that person in a nursing home or in an assisted living facility. Next slide. I believe that's Ashley.
Thank you. So I'm now going to talk about some special considerations for survivors of sexual assault. So as Bobby mentioned earlier in the slide, there's a new law that came into effect as of October 1st, 2020. And survivors of sexual assault and child sex abuse are eligible for relief under the protective order statute based on this law. And these types of abuse aren't necessarily related to intimate partner violence. These are sometimes referred to as non-domestic sexual assault, or like I said, child sexual abuse. So in the past, these survivors, these crimes were eligible for relief under the peace order statute. However, the remedies weren't as robust and it didn't offer as much protection. So the new law that now moves this eligibility to the protective order statute cover those who have been a victim of rape or sexual offense or attempted rape or sexual offense within the past 6 months. And this is defined in the Maryland criminal law code. There are also several adults who are eligible to file for a protective order on behalf of a minor child who's a victim of sexual abuse or the other types of abuse listed in the statute. Those are a person related by blood, marriage, or adoption, other adults who live in the home, and then also not listed here, but the state's attorney can also file, or the Department of Social Services can file on behalf of a minor. Okay, next slide, please. So what types of abuse are covered by the Act? So there's assault in any degree. This includes battery, an act that could cause serious bodily harm, a threat of imminent serious bodily harm. And imminent bodily harm, again, it can include threats of harm, but it has to be something that is reasonably likely to occur. It can't just be like a fear. And rape or sexual offense, as I described, and also attempted rape or sexual offense. False imprisonment, stalking, and revenge porn. And these are all defined in the law. But in revenge porn is the distribution of intimate images, pictures or video without the consent of the other party. Next slide, please. So where can you apply for a protective order? So if the courts are open, you could go to the district court or the circuit court to apply. Next slide. And if the courts are closed, you can go to any of the local commissioner's offices in your county. The court commissioner's offices remained open during the pandemic, and that was where you would apply for a protective order. As of right now, the courts are officially reopened. And so you can go to the district court or the circuit court, and then on the weekends or after hours, the commissioner's offices. So now I'm going to turn it over to Dorothy to talk about the process of applying for a protective order.
Thank you, Ashley. During this presentation, you're going to hear us talk about three kinds of protective orders: interim protective orders, temporary protective orders, and final protective orders. And I'm going to describe to you what they all are. Next slide, please. Before we created the interim protective order, you could only get a protective order during business hours. So that was Monday through Friday from 8:30 to 4:30. And that didn't really make a lot of sense because most domestic violence occurs during nights and weekends. And so we wanted people to be able to get a protective order when the courts were closed. And we created the interim protective order where the public could apply for a protective order through, as Ashley just described, the court commissioner's stations. In every jurisdiction, there are court commissioners who are available on a 24/7 basis. The interim protective order is only available when the clerk's office in the court is closed. And this is a particularly important distinction because during the pandemic, the courts were never technically closed, but the clerk's offices were closed and the public was generally not allowed in the court. So during the first few months of the pandemic, the only way to get a protective order was by applying through the court commissioner's station. An interim protective order is only valid until the temporary protective order hearing. The court commissioner can order the respondent not to abuse the person eligible for relief, not to contact the person eligible for relief. It can order the respondent to vacate the family home. It can grant use and possession of the family home to the person eligible for relief. And if the parties are living together at the time of the abuse, the court can order custody of the party's minor child or children to the person eligible for relief. The interim protective order must be personally served by law enforcement on the respondent to be effective. After the interim protective order is granted, the case is transferred only to the circuit court, only to the district court, not to the circuit court. Next slide, please. The interim protective order is only good until the temporary protective order hearing or the end of the second business day after the district court's clerk's office is open again. And that second part about the clerk's office was created, it was called the snow day provision. In 2010, we had about 45 inches of snow and the courts were closed for several days. And law enforcement and judges were unclear whether the interim protective orders ended because they weren't heard by the second business day. So during that session of the Maryland General Assembly, we created this snow day provision. This was an incredibly important provision during the pandemic because the clerk's offices were closed. The court commissioners were allowed to hear the protective orders on a 24/7 basis. Otherwise, the commissioners can only hear when the clerk's office are closed. So the interim protective orders stayed in effect until the court moved to a new phase and the clerk's offices reopened. The standard of proof at an interim protective order is reasonable grounds to believe the abuse occurred. This is a very low standard. The court commissioner is only hearing the petitioner's testimony. So as long as the petitioner can show that they're a person eligible for relief and describe an act of abuse as defined in the statute, as you've heard all of these from Bobby and Ashley, then the interim protective order should be granted. Next slide, please. Temporary protective orders are heard by judges. This may be the first time the petitioner is appearing, or if the petitioner filed for an interim protective order, this may be the second time the petitioner is appearing. And again, the standard of proof at this level is reasonable grounds to believe that abuse occurred. At a temporary protective order hearing, the judge can order the respondent not to abuse the person eligible for relief, not to contact the person eligible for relief, to vacate the family home, grant use and possession of the family home to the person eligible for relief, possession of the family pet to the person eligible for relief, custody of the party's minor children can be ordered to the person eligible for relief. And at that stage, the judge can also order law enforcement to use all reasonable and necessary force to return the minor child or children to the custodial parent after the service of the final protective order. The court can order surrender of firearms, but only if the abuse alleged involved a gun, the threat of a gun, or the abuse caused serious bodily harm or threat of serious bodily harm. Next slide, please. The temporary protective order is only good for 7 days after it's been served, and the judge can extend the temporary protective order as needed for up to 6 months to effectuate service. Next slide, please. Either the interim protective order or the temporary protective order must be personally served on the respondent by law enforcement. There's no cost to the petitioner for either filing fees or service fees. Once the respondent has been personally served with either the interim protective order or the temporary protective order, all other orders, including the final protective order, can be mailed to the respondent. Next slide, please. Before we change the law to allow judges to extend the temporary protective order for up to 6 months, the temporary protective order ended if the respondent was not served. I think we need to go one more slide. No, I'm sorry. If you could go back one, sorry. Before we change the law, the temporary protective order had to be served within 30 days. And during that time, some respondents simply hid out for 30 days to avoid being served. When we changed the law to allow judges to extend the temporary protective order for up to 6 months, we found that it was a huge burden on petitioners to have to come back to court every week for 6 months. So some petitioners had to take off from work or find childcare, or they didn't have transportation. So in response to that, we created the waiver rule. And the way the waiver rule works, the petitioner must appear at the first final protective order hearing. If the respondent has not been served, the petitioner can file for a request for a waiver of appearance. The petitioner must register with Fine Protective Order. Fine Protective Order is an electronic notification system that notifies the petitioner by phone or email when the respondent has been served with the temporary protective order. When the petitioner has been notified that the respondent has been served, then she or he knows to attend the next final protective order hearing. After the court may excuse a petitioner for non-appearance one time in case there's been a Fine Protective Order filed. After that, the case will be dismissed. Once again, the court cannot hear the final protective order unless the respondent has been personally served by law enforcement with either the interim protective order or the temporary protective order. The standard of proof at the final protective order is a preponderance of the evidence. Now, some people may not completely understand what these standards of proof are. I think most of you have heard of, in a criminal case, the standard of proof is beyond a reasonable doubt, and that's maybe 98% or 99%. Clear and convincing, which is the next level of abuse, you have to prove it by maybe 70% or 75%. And a preponderance of the evidence, which is what it is here, is maybe 51%. So the judge just has to believe it a little bit more than not believe it. Final protective orders can be entered by consent. The benefit to the respondent of consenting is that there's no finding of abuse by the court. If there's a companion criminal case, the respondent often consents. A final protective order can be issued for up to 1 year. Because the respondent must be personally served before the final protective order can go forward, the respondent does not have to be present at the final protective order hearing. And you may be wondering how these cases have been heard during the pandemic. Currently, some courts are hearing the cases in person, some are hearing the cases remotely, and in some cases, it's up to the judge or the attorneys or the litigants. So be sure to ask your attorney or the court how the case will be handled. And Bobby is next.
Bobby's muted. Okay.
Yeah, I'm sorry. What can you ask for in a protective order? There are a number of kinds of relief that the court can order in the protective order. The court can order the respondent to refrain from abuse or threats of abuse or harassment. They can order the respondent to refrain from contact with the petitioner, to refrain from entering the home and the residence of a victim, to vacate the home and so that the victim has use and possession of the home, and to stay away from work, school, or homes of other family members. You can also ask that the respondent stay away from daycare, various places that you may be or that your children may be. So violations of this kind of order to stay away from, not to abuse, not to contact, to stay away, is mandatory. It's enforceable by mandatory arrest if committed in police presence or by filing criminal charges. Next slide, please. The second type of relief is they can ask the abuser to stay away from daycare. They can award temporary custody to the petitioner. They can order temporary visitation and fashion a schedule to allow that visitation to happen. They can order temporary family maintenance, and Dorothy's going to talk a little bit more about that later. Use and possession of a jointly owned vehicle. Order the respondent to participate in counseling, abuser intervention program, drug treatment. They order mandatory removal of guns, possession of pets, and any other relief necessary to protect the petitioner from abuse. Now, this second type of relief is enforceable only through a contempt of court. So the petitioner, after getting the protective order and having a violation of one of these things, would have to go back to court and file for contempt of that protective order, and there would be a hearing. Next slide, please. If you've asked the judge to order the abusive party to vacate the family home, the judge will consider these factors: the financial resources of each party, the existence of alternative housing, does either party have somewhere else to go, the history and severity of the abuse, whether or not there are criminal charges pending, the needs of children that reside with the parties, and whether the parties were living together at the time of abuse. Also, whether the home is titled or leased in either or both of the parties' names. Next slide, please. In a protective order, the judge can also order custody. Without a custody order, both parents have equal rights of custody to their biological or adopted children. Each has 100% rights of custody. So nobody's preferred over anybody else. Both parents have equal rights. A custody order gives priority to one parent over the other parent. So the judge may order that the petitioner have custody. The judge may order law enforcement to use all reasonable and necessary force to return the child to the custodial parent after the service of the order. And that's important because often we see that the other party removes the children and the petitioner doesn't know where they are or they can't get them back. So that's a really important piece to know, that the police can help you get your children back once you get the temporary order or the final order. Now in Maryland, there are two aspects to custody: physical custody and legal custody. Next slide, please. Physical custody is where the child actually lives, where the child attends school and spends his or her nights. So this is, who the child actually physically lives with. Legal custody is the authority to make major life decisions affecting a child, such as medical decisions, educational, religious, and daycare decisions. Often the judges in a protective order will generally just address physical custody. Sometimes they will address legal custody, but it's more likely that they'll just address physical custody. Next slide, please. And the court can also order, if the court decides to order one party to have custody, the court can order a visitation schedule or a means of visitation for the other party. And the court must, in ordering visitation, the court must give primary consideration to the welfare of the child and the safety of the victim. So there are several kinds of visitation that the court can order. The court can order unsupervised visitation. So that means that the other party has the child. Sometimes it's depending on a schedule, has the child, but doesn't need any supervision. They can order supervised visitation, which generally means someone is with the other party when they're visiting with the child. Sometimes that's formal, like one of the visitation centers. Sometimes that's informal, like a family member of the, of the party or even of the petitioner, but someone who that they believe will supervise the respondent with those children. Or if the judge feels that the children aren't safe and the victim isn't safe with visitation, the judge can order that no visitation happen at all. Now, sometimes when there is a no contact order, the judge can order the parties to correspond via one of the parenting apps or sometimes in text to arrange visitation. But it's difficult and you have to be careful because it puts you back in touch with the abusive party when that happens. So when you're going in to ask for a protective order and ask for the things that you want in that, you need to keep all of these things in mind. The judge likes it when you have a plan. They like it when you have something to present them that says, this is my plan and this is how I can make this happen. Okay, next slide. I think that's Dorothy.
Emergency family maintenance requires the duty of support on the part of the respondent to the person eligible for relief. So it's similar to either child support or alimony. So you either have to have a child in common with the respondent or you have to be married to each other. So parties who go into court, if they're not married and they don't have any children, they would not be entitled to emergency family maintenance. Next slide, please. The court can also order the use and possession of a jointly owned vehicle. It has two requirements in order to be able to do that. The vehicle actually has to be jointly titled. So both parties have to be on the title of the vehicle. And the vehicle has to be needed by the petitioner or the person eligible for relief for work or the care of a minor child. Next slide, please. The court can also order possession of the pet. The pet has to be a pet of the person eligible for relief or the respondent or both. But there are some people who are in very dangerous situations who may not leave if they can't take their cat or their dog or another pet with them. So this was an important provision. And I believe Ashley is next.
Thank you. So for the final protective orders, there are 3 durations that can be ordered by the court. The first one is the regular final protective order, and this lasts for up to 1 year, and it can be extended for an additional 6 months for good cause. Good cause is a pretty low standard that the courts will look at to see if you're eligible for your protective order to be extended. The second duration is the 2-year final protective order, and this is available for persons who had a final protective order of 6 months or longer in the last year against the same person, and it's available for persons who were re-abused while that final protective order was still in effect. And this could also be someone consented to the 2-year duration. For the permanent final protective order, this is available to persons who have an interim, temporary, or final protective order whose abuser has been convicted of any crime and sentenced to at least 5 years and has served at least 12 months of the 5-year sentence or the at least 5-year sentence. The relief is limited to no abuse and no harassment and no contact. Next slide, please. Mutual protective orders are only available if both parties have filed against one another, and neither party could have been the primary aggressor, and neither party could have acted primarily in self-defense. to get a mutual protective order. Next slide, please. So either party is eligible to appeal for a protective order, and the appeal must be filed within 30 days of the grant or denial of a final protective order. And while the appeal is pending, the final protective order does remain in effect. I think there's some questions before we kind of conclude.
Yeah, I saw one question about visitation, and the question was, is it recommended to exchange children at a police station, or can that be included in the protective order? It certainly can be included in the order, but it can be a police station. It can be, we've had parties exchange. Now in the pandemic, it's been a little bit more difficult because we'd had parties exchange at bookstores, at McDonald's. It's wherever you feel safe in exchanging the children. What I say to people when they're going to do an exchange in person is you need to always take someone with you. Make sure there's someone with you that can, first of all, it makes you feel safer, but secondly, you have a witness to say that you didn't do anything improper when the exchange happened. But the judge can order any of those. And I guess one more thing I was going to say before I stop. So all of these things and what the judge can order is specific. In consents, you can agree to many things. You can agree to things that aren't specifically like what the law says, but that has to be done in a consent. If the judge has a hearing and is going to order relief in your case, they're limited to the relief that they can order in the law.
And I think, Dorothy, did you want to say something? I was going to give the next question to Ashley, unless you wanted to add something, Dorothy. Okay, so Ashley, the next question was, is there a specific intent required with revenge porn?
Yeah, so with the revenge porn statute, there's, 3 considerations that the court looks at. So no one can knowingly distribute any visual representation of someone else that's identifiable of their intimate parts. There's further description in the statute, but intimate parts can be pretty self-explanatory. And with the intent to harm, intimidate, harass, threaten, or coerce the other person. And under the circumstances where the person had a reasonable expectation that the images would remain private. So I think this statute comes about with, sexting or some of those things that, happen in intimate relationships. And most of the time one would expect those to remain private. And so the intent of this statute is to protect those images from being used against someone with that, intent to intimidate, harass, coerce, or threaten someone else.
Okay, thank you. The next question was, do I have to be bleeding and have serious bodily harm in order to get a protective order? What if my abuse is only mental anguish or verbal abuse? Perhaps Dorothy, if you want to answer this, or whoever can jump in.
I'd be happy to answer this one. You certainly don't have to be bleeding, and you don't have to have serious bodily harm. There's a lot of acts of abuse that are covered, from fear of imminent serious bodily harm. Many assaults don't leave you bleeding. It could be pushing, shoving, slapping. Stalking is covered. There are a lot of kinds of abuse. There are a lot of acts of abuse that don't require you to be bleeding or beaten up really badly. The statute does not cover verbal abuse or mental abuse unless it's a verbal threat. So if somebody's standing over you saying, "I'm going to kill you," that might be enough to get a protective order. But if they call you on the phone and threaten you like that, chances are you can't. So it covers a pretty wide range, but it doesn't cover everything that abusers, have done to victims and survivors.
And I'd just like to, I'm sorry, Delegate Bartlett, I'd just like to add one thing. There's abuse that some people don't even ever think of as abuse, especially under false imprisonment. You know, we have clients who have been kept in a house and not allowed to leave for a period of time, kept in a room. And the most common thing is someone who's in a car with the abusive party who's driving and won't let you out and is driving erratically and driving dangerously. So I think you have to think about all of those issues and figure out if, you know, if any of those things happen to you, because people sometimes don't think of those as abuse.
That's a good point, Bobby. Thank you. Another question that came up is if the abuser is not arrested when they call the police or the conduct is not in the presence of the police, could they still get a protective order, or is it less likely that it will be granted? So I think the person is concerned that if they let the police leave without taking any action at that time, will that lessen their chances of getting a protective order?
I'm happy to jump in on this one. I think it's really important to realize that that one big difference is a protective order is a civil action and it's not a criminal action. And lots of people would rather go down the civil route than the criminal route. Some people want to go down both. Some people just want to do the criminal route. You do not have to call the police. The act does not have to occur in front of the police. You just have to be able to prove to the court by this 51%, just slightly more, the court has to believe that you're a person eligible for relief and that one of those acts of abuse that I believe Ashley described occurred. And so if you want to bring any evidence that you have with you, so if you have pictures of the event, or if anybody witnessed it, or if you have torn clothing or pulled hair or anything that's going to show the judge that this act occurred, bring it to court with you. That can be incredibly helpful. And even if it's just your word against the respondent's word, lots of times just the way you act in court, the way you seem in court, the judge will believe you. So don't be afraid to pursue it, even if you haven't called the police or you don't think you have a lot of evidence. And all the domestic violence programs and everything that's listed here, anybody who you call can help talk you through whether you have a case that seems like it would be how the statute defines abuse. Great.
Thank you. Last question, and I think it was alluded to in one of the slides, and that is it required that the abuse survivor is present in court, or if the victim is present in court, can someone else act on that person's behalf if they do not feel comfortable confronting their abuser in court for the protective order?
I mean, I'm happy to answer, but I feel like for many, other than the vulnerable adults and some of the things with, kids and all that, if it's adult domestic violence, yes, you have to appear in court. Nobody can really do it on your behalf. I think there are pros and cons on that we have discussed over the years, but because it's a civil case, you want to make sure that the person eligible for relief, the petitioner, is somebody who wants to go forward with it.
Great. You all have been super informative. I've been getting a few messages from individuals who are watching, and they have found it very interesting and very helpful. Unless anyone has anything else that they want to add at this particular moment, we're going to go ahead and give a list of the organizations that Dorothy alluded to that are very helpful to anyone who is seeking a protective order, and or anyone who is just seeking counseling. And there's also a whole host of other resources that these organizations provide. So this list so far, we have the Maryland Network Against Domestic Violence, the Maryland Coalition Against Sexual Assault, MCASA, SALI that we mentioned earlier, and House of Ruth Maryland that we mentioned earlier. And we also have the Maryland Legal Aid Bureau, HANA, and the National Domestic Hotline, which is not clear here, but perhaps if you can't see it here, you can Google National Domestic Violence hotline and get that information. So I want to thank everyone again for being able to attend tonight and to present tonight or today with such great information, and just being able to help someone who may need to refer to this. The beauty of technology is that this is not a one-time showing. If you want to refer to this video, because it is on YouTube, someone can refer to it later, or you can refer a friend if you don't remember all of this wealth of information. So thank you for everyone for tuning in. I don't know if we have any other questions. I don't believe that we do, but if anyone has anything that you wish to say, please let me know, please indicate. Bob, you look like you were going to say something. Okay. All right. All right. Great. Well, thank you again. I appreciate you, Dorothy, Bobby, and Ashley. You all work with great organizations, and I am excited about the work that you do. Thank you for continuing, to help individuals for such a long time, and all the individuals that you will help in the future. Thanks again. I appreciate you for being here. On behalf of my co-chair, Shelley Mintz, we appreciate you being here. Thank you.
Okay, the stream has ended.